of the day, and I'm going to start over again. The title of the case is People versus Rosalind Ray Keenan. The allegation is that on or about May 16th in the village of White Pigeon, she did resist and obstruct a police officer and drive with a suspended driver's license. Resisting and obstructing is a felony now. It's punishable by up to 2 years imprisonment. And driving suspended as a traffic matter, punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. Someone who is identified as Rosalind Keenan is present, and she wanted to explain more about that. We'll give her a chance to do that, but Prosecuting Attorney David Marvin is here, and he's representing the state. So let me ask you again, are you Rosalind Ray Keenan?
I'm here as sui juris impropria persona, Rosalind Ray family of Keenan, beneficiary. Is this on record?
Yes, everything has to be on the record, so it's all being recorded.
Okay, I'm here on the special appearance, and I'm a free woman on the land. I'm here under fraud, menace, and duress. I am the private woman, Rosalind Ray
All right.
Keenan. The all capital mentioned name is the only appellation given to me. Anytime I autograph is to be done in a certain manner that I have here.
This is how the case opens. Before we even get to the charges, Miss Keenan makes it clear she's not playing by the normal court rules. She's using the language often associated with sovereign citizen arguments, where a person challenges a court's jurisdiction or their legal identity. Judges have heard this before, and it almost never ends well for the defendant.
Under bond, she signed it as Rosalind Ray Keenan, beneficiary, with quick bail bonds. All right, now we've got another issue. This is a felony charge. The first one is. The second one is under the Motor Vehicle Code. And it requires that we have a preliminary examination, or it requires that you're entitled to a preliminary examination. We had a pre-exam conference last week, and you expressed at that time that you did not wish to have an attorney. You're here with you this morning without an attorney, and we'll address that in a moment. You've been talking with Mr. Marvin. You have an absolute right to represent yourself. I normally don't recommend it. Mr. Marvin will sit down and talk with anybody, whether they're an attorney or whether they're a layperson. So you and he have been meeting to discuss this. Mr. Marvin, is there a plea offer here?
There is. And I'll tell you about that, but I wanted to mention that this is, I believe, the third time we've sat down, and so this is dragged out a bit, but only because she's not represented, and in these three separate meetings and adjournments, the court has allowed those, and I appreciate it. I have spent a lot of time with her and her son, who's here. He's always been here, and they're very honest and they're good intended.
Thank you.
And I think that we've come to a resolution that I believe is fair. I've offered, I'm going to state it for the record, and only time will tell if she's going to accept it in hopefully 2 seconds. But what I would do is offer an attempt resisting and obstructing and dismiss count 2. And I would ask that the court set this for sentencing at a later date, and I'd ask for 6 months. And if by that time there's no other incidents with law enforcement or any other reason to continue, I would dismiss this, or at any time before that if I felt that it was necessary. And again, after working with her, I don't think this is the kind of thing that should be, I would hate to see this upstairs as her first felony. I think that
This is one of those rare moments where you can see a prosecutor actually trying to help the defendant. He's met with her multiple times, knows her family, and is offering to drop a felony entirely.
Is offering to dismiss the felony charge and reduce it to a charge called attempted resisting obstructing a police officer. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Do you understand that charge?
No, I don't understand the nature and the cause of the
All right,
charges.
Mr. Marvin, let's just do a prelim. I'm not going to tap dance with her. You may be more sympathetic about this flat earth nonsense than I am. But if I'm going to have to argue about everything from who she is to what the charge is, it'd be easier to just put on the prelim. From the affidavit of probable cause, her conduct was outrageous with a capital O. And so I'll give you one more opportunity, Ms. Keenan. Mr. Marvin is agreeing to dismiss the driving suspended charge. The record shows your license is suspended from Indiana and you don't have a valid Michigan license. That's a benefit. It won't affect your driving privileges.
Excuse me? What did you say about the?
It's a benefit. And
No, before that, about the license.
He's dismissing it. And it won't affect your driving privileges here or Michigan or Indiana.
A felony can follow you for life. And yet, instead of locking this deal in, she's preparing to fight the system on legal theory grounds. Clip 3. The judge is practically spelling out, "This is a good deal. Take it." They're trying to dismiss the suspended license charge, so it won't hurt her record in Michigan or Indiana. But you can see she's focused on technicalities instead of the big picture.
Well, I don't understand that.
Mr. Marvin, let's just put on a prelim.
Games. I'm serious.
You are playing games. And first of all,
I'm
you don't.
trying to advance to
all right,
what I'm
stop.
here
You don't
for.
interrupt the judge, whether you're a flat earther or not.
I'm not flat earth. So.
All right, well, this crazy stuff you're saying, I've got very little patience for it.
Here's where patience starts to crack. The judge goes from neutral to visibly frustrated. When you're in court, especially facing possible jail time, interrupting the judge is a fast track to contempt.
So, may I ask, what jurisdiction is this, civil or criminal?
This is a criminal case, which points out the fact that you could use a lawyer if you can't tell the difference between a civil and a criminal case. Criminal case means you could go to jail, in this case, for up to 2 years. In a civil case, there's no possibility of jail. It's usually over money damages or other types of non-jail relief, like other types of non-jail relief. So yes, this is a criminal case.
Well, thank you. So, you said the record is on.
Yes.
Could the record of the court show that this is a criminal action? And my next question is, I know that the Constitution grants the court 2 types of criminal jurisdictions. One is criminal jurisdiction under common law, and the other is criminal jurisdiction under admiralty or military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Under which of these 2 jurisdictions is the court intending to try me?
This is statutory jurisdiction of the law of the state of Michigan. It's not any of those things, including the wacky admiralty clause people try to invoke. This is criminal jurisdiction authorized by the state legislature here in the state of Michigan.
Thank you.
This is the core clash. She's asking under what jurisdiction the court is operating, citing constitutional clauses that have no effect here. The judge calls it wacky and makes it clear. This is Michigan state law. Period. Whether you agree with the system or not, that's the only answer that matters in that room.
The conduct in here in the affidavit or the bond information report is outrageous with a capital O. And you could very well go to jail for a substantial period of time. Mr. Marvin was trying to extend to you an opportunity to avoid that option, but you're wasting all of our time with this stuff that doesn't have any legal merit. I'm offering to give you an attorney who can actually argue any legal merit or advise you or assist you in this regard. But we've had some White Pigeon police officers here on overtime for several hours. They're still waiting for you to decide what you wish to do. I haven't even gone over the first. Well, first of all, we had to establish who you were. That took much more time than it deserved. Secondly, I'm trying to determine whether you wish to have an attorney or not. Again, you do have the right to represent yourself. You wish to, but you've exhibited to me that you don't understand the law, and you're at risk of being incarcerated for this conduct. So to further comment on Mr. Marvin's offer, if you pled to the charge of attempted resisting and obstructing a police officer, he offered to defer the sentence for 6 months, and if there were no further problems, to dismiss it, which is very generous based on the police report, bond information that I came.
Point the judge is almost pleading with her to take the misdemeanor, stay out of jail, and walk away without a record, but she's locked into her legal strategy. And it's like watching someone push away a life raft in the middle of a storm.
I know I can peer for myself. I'm competent and I am confident. Okay?
All right.
So
The next question is, are you willing to accept Mr. Marvin's plea offer to plead to the misdemeanor charge?
I wasn't completed with what I wanted to say to you, please.
Okay.
May I? Thank you. So I wanted to say that I don't believe it's a violation of your oath of office if you did your duty under the Constitution, because I'm seeking legal intent. I have the right to peer for myself in order to intelligently defend myself. I have to know the jurisdiction this court is operating under, because the rules of civil procedure under common law jurisdiction are very different from the rules of civil procedure
All right,
under
stop.
admiralty or military
Stop.
tribunal venue.
Stop. We went through this before.
I know.
This is not civil
It's
procedure.
the Sixth Amendment grants me the right to know the jurisdiction being applied,
And I told you what it was.
and it gives you the duty.
All right, stop. If you interrupt me one more time.
Here's the breaking point. She keeps talking over the judge. He warns her and finally holds her in contempt. That's an immediate ticket to jail for 24 hours. It's a dramatic moment because it didn't have to happen. She was offered a way out minutes early.